So, again, tonight's our session on estate settlement. And this is the second of 4 sessions. The other 2 are in the fall. Before I get too far in, however, I want to just review the lifespan of plans at work and show you where we are in the whole thing. The upper part here, of course, is where people do their planning with us. Most of you have come in through the classic 3-step strategy, estate planning, and of course the step 2 program we now call the Empowered Legacy Program. And that starts with financial integration, meaning funding, and then the Continuous Commitment Compact is really the step 2 program. At later parts of people's lives, they can enter the Proactive Elder Law program, and that deals with issues as people get older. And then, of course, we get to estate settlement, and that's where we are tonight. We're talking about this part right here. We're going to talk a little bit about these other sections over here, but we're in the estate settlement, in the settlement security system. That's what we're talking about now. So this is the family education program. It's a nuts and bolts program is intended for clients, and trustee training is intended for helpers, and of course they're both together. Trustee training is for helpers and beneficiaries. And what are the clients' goals for this program? In talking to our clients, their primary goal is to make things smoother and easier for those that follow: beneficiaries, successor trustees, and everybody who's going to be helping them. Our goals for the program, however, we have a lot more items. First, we want to familiarize you with the settlement process for your peace of mind. And we want to reinforce your current commitments and set proper expectations. We also want to help you evaluate your helper selections, because sometimes people learn things and a helper will attend and say, I really shouldn't be doing that, or something like that. And that can be helpful when they know what they're supposed to be doing. We want to know that we want you to have a better vision of what the impact of your planning is, and discuss concrete steps you can take to make the process better for your loved ones. Without those concrete steps, it can be kind of confusing. So we want to build your confidence in the process, explain the commitments that you make, and to set the proper expectations for the whole thing. And we want to prepare you for the issues that you're likely to face. And finally, we want to provide an overview of the tasks to be performed and let you know how you can help how you as helpers can help the client better prepare for things that come and happen. We would, however, like to have your goals for the program, and we'd like you to share them for us if there's beyond what I've already said. So, you can send us a private email. My email is fbridges@hdlawgroup.com. And you can send it to Lexi Hewlett. Her email is lexi@mhlawgroup.com. Or you can send them to Les Hoiberg, and his email is les@mhlawgroup.com. Note that there's an HD Law Group and an MH Law Group. We're still in the process of putting everything together under one roof, so everybody has slightly different emails. You can register on the website, that's hdlawgroup.com, and at that place, that's where you sign in using the login name step 2, step with a space, number 2, capital S on step, and the password is member with a capital M. And at the bottom of the resource page, there is a form that you can fill out that lets you register for the program. It basically just gives us your email address and some other information so we can get you into our records. You can do the same thing by simply sending me an email, and we'll make sure you get into our records so that you get notice of all these sessions. Please also remember that there is the First Call program. Under that, if you've attended these sessions, if you're a helper, you can call us anytime with any questions you may have about our clients' planning. We'll tell you what we can tell you. And let us know what's working and what's not working. Please feel free to call us. So during your lifetime, dear clients, there are some very proactive steps that you can make. First, of course, is to fully fund your trust. Now, fully fund your trust means actually having everything retitled, but also having written confirmations of everything the way they are, and providing us with updated information in the first part of the year when you fill out your asset review reports. Excuse me. Communicate what to do steps now. In other words, talk to the people who are going to be your helpers, communicate to them what you know about what they're supposed to do. In your red books, there is what's called a
Frank?
Frank, for some reason you're frozen.
the DCS account and complete your information there. That's easy to forget. You should actually be sure that that's completely filled out and that all of the records that you've got in there are okay. I have a notice on my screen that my internet is unstable. Can somebody unmute themselves and tell me whether you're able to hear me?
We lost you for a bit there, Frank.
Where'd you lose me?
You said something about the red book, and after that,
Yeah, the
All
red
right,
book
I'll
and the
go back to-
location list is when we lost you, Frank.
Okay, I'll start there. You didn't lose much. All right, so I'll just repeat. The location list is in your red book. That's basically a guide for people who are your helpers to pick up and actually, be able to know where everything is that you've left for them to know, where various different important papers are and things like that. So many of you have a DCS account. What that is your digital communication service. What happens is we notify them if you die, and then they notify all of your digital assets as to who it is that you have designated to have authority to be in your account. So they notify banks, Facebook, Google, all those people, so that when they get notice that you've died, they don't shut out the people who are supposed to have authority to do that. So that's what that's for. And also in your red books, there is a section for final instructions. There's no specific form for a memorandum to put in there about what your final instructions are. So you should give some careful thought to it. If you want us to talk to you about it, we're happy to do that. And if you want us to word process them for you so you can put them in a neat format in your book, that's fine too. But there's no specific format for that, and whatever is genuine from you is, I'm sure, going to be very comforting to the people who pick up the book. Consolidate your investments. If you've got 4 or 5 different investment accounts, it's very helpful to the people who are going to be your helpers to only have to do with one account. And also, if you have specific certificated securities and you have a dividend reinvestment program, that also can be very confusing. So it's very important to make sure that people know what securities are on the dividend reinvestment program. You should also be sure to attack clutter. I've had stories of people, fortunately not my clients, but some other people who have said that they spent months going through the garage and trying to find all the important papers in the boxes there. So make sure that you attack all the clutter that you've got in your house and various different things. Try to make sure your attic is well ordered a lengthy, long-term, difficult project for the people who are trying to help. Complete your special stuff list and your TPP memos. Those are your tangible personal property memos. Those are the memoranda that say, I want this particular piece of property, personal property, to go to this particular person. The latest memorandum about a particular item is the one that's effective, and your trustees are supposed to implement those. And of course, keep us very clear on what your beneficiaries and helpers' contact information is. Make sure that if there's any changes in that we know what it is, so we can make sure that they get invitations to these sessions if they want them, so that we can contact them if need be. So the helpers and beneficiaries also have some proactive steps that they can do. One of them, of course, is to attend the trustee training. That's the nuts and bolts 2 and 3. It's also really important for beneficiaries to attend the beneficiary training. That's nuts and bolts 4. Nuts and bolts 3 is in October. Actually, nuts and bolts 4 is also in October. And we gave the clients the annual calendar of events. Anything that's in the fall is tentative in terms of scheduling, but those October dates seem like they're going to be fine. So tonight there are 4 goals for you. One is to know the law firm name and contact information. Remember that there's a process, and the process produces the results, so it's important that we follow it. We want to give you an idea of the types of issues you're going to deal with, and we want to encourage interest in planning and participation in the planning for the beneficiaries. So what do you do when someone dies? Well, the first thing is to call the law office. And that's really the beginning of the process for us. It's important that we hear from you, because there are some early information that's important for you to know so that things don't get out of kilter. And also there is a transfer process navigator that I'm going to be going over. And that's the process that you follow from there, from that first call. We don't need to know before the funeral occurs, but as soon as the funeral occurs, and before would be good, but as soon as the funeral occurs, we need to know that someone has died. And of course, if we can attend the funeral, we'd like to know beforehand. And for those of you who are watching this recording online, this page will have the answer to the quiz that you'll take to tell us that to confirm for us that you actually attended. This is one question. So the first 2 steps are call the law office and follow the transfer process navigator from there. So when you are preparing for the settlement counseling session, there is something called a common concerns memo. This is a memorandum that has been prepared so that people can get their initial concerns answered. Everybody who has had experienced a death, there are often very common questions that people have. What should I do about the safe deposit box? What should I do about locking the house? Things like that. Those are all things that are in the common concerns memo, and it covers a lot of ground to help you. So that is located at the website. That's hdlawgroup.com. And if you go to the main website, that's heritagedesignlaw.com, and click on the clients enter here button. That's a red button that's pretty obvious on the first page of the website. That will take you to hdlawgroup.com, and the sign in, which again is step 2, is the sign in name, and member with a capital M is the password. There's also another memorandum that says what to do when a loved one passes away. That's also very helpful. Those are on the resource page in the website. So here are some key concepts that I want you to be sure that you understand in the overview here, the smooth transfer template, the settlement commitment clarifier, the transfer process navigator itself, and the settlement coordination plan. The settlement coordination plan is a specific plan where we go over with families relating to their particular case when the time comes. So we're not going to spend a lot of time on what that is right now, but the first three are important for you to know. So the smooth transfer template basically says these are the various different things that people need to know and to accomplish in order to make things go smoothly. So you can see that it's always important for both you and the beneficiary to communicate. Ensure that you have proper funding, and that's our client's primary job. Support the proper funding, and that is very helpful for the beneficiaries to support our clients with that. Attend your annual client meetings and your client update program sessions. That's for our clients. And for beneficiaries, support the attendance of our clients to the ACMs and CUPs. Some clients have difficulty getting there. When there is that kind of difficulty, we want to know about it because we have some systems that enable us to accommodate any disability problems that occur. Attend, of course, nuts and bolts for both clients and beneficiaries. Pursue wealth reception planning. That is the topic of the fourth nuts and bolts, so I won't go over that very much tonight. But and then, of course, communicate, again, is really important. Then there's the settlement commitment clarifier. Okay, so these are our basically our commitments. The successive trustees, we want them to understand what reasonable expectations they should have. Respect the common concerns memo, which tells you what not to do and what to do. Honor the settlement productivity plan that we get together when we put the settlement together. Forward your mail. If you receive mail, forward it to us immediately, because there are times when we work with financial institutions that will only send things to the clients or to their successor beneficiaries. They won't send them to us. And so you'll get things in the mail that you don't know where they came from or why they came to you, but you'll open them and you'll find that there are things related to the estate settlement, and you should forward those to us. That also happens in the funding process as well. When we send you things to sign, please return them immediately. Resist going direct. What that means is don't really try to deal with financial institutions too much unless it's really urgent. Let us deal with the financial institutions. It can cause a lot of confusion when we're dealing with them, and then the client or the successor trustees also deal with them. Things can go astray. And always, when we have a meeting, always agree on what the next step is after each contact, so that we all know what's to expect and what's the next thing that's going to happen. For us, we want to meet and exceed your reasonable expectations. We want to conduct a thorough settlement counseling session, and sometimes that may actually require 2 settlement counseling sessions. We want to honor the settlement productivity plan. We're going to timely review our mail that we get from you and forward a mail that we get that's for you appropriately in a timely manner. And we want to handle matters efficiently and professionally, as we always want to try to do. And again, always agree on the next step after each contact. And if we forget to do that, please remind us. So here is the Transfer Process Navigator. This one is actually designed for an estate that's going to file an estate tax return. There's also one that is for estates that don't, but almost all of our clients have at least a Massachusetts estate tax return to file. So this is the one that I put up. So the first step up here of course is notification. That's when you call us after the death. And that's when we want everything to stop. Don't take a lot of actions. Read that common concerns memo. Only do what that says to do, and don't do anything else. And then we schedule in a couple of days to 2 weeks our first settlement counseling session. And at that, we're going to be talking about cash flow. We're going to be talking about a lengthy to-do list, things that need to be done. We're going to be reviewing the assets. So we're sure that we know where the title to the accounts is and that it's all correct. We may need signatures on things. And of course, with the COVID-19 problems, it's difficult for us to get signatures. And so we're finding that it's really helpful for people to have a printer and even a scanner. And often it turns out that people don't. So things have to go out in the mail and back into the mail, and that takes a lot longer. So just a word to the wise, if you have a printer at home, that's very helpful. And of course, in some cases, there may be court papers that we need to deal with. So after that, what happens is we go through this process of valuing the assets and retitling the assets in the name of the trustees of the administrative trust. And I'll show you what that means in a minute, but the administrative trust is what takes over when the person dies. That's in Article 6 of their trust, and it automatically takes over so that the successive trustees who've been appointed by the client become the trustees, and their job again is to get control of all the assets. So if you have an account in the name of your trust with you as your trustee, the name on that trust has to be changed to the new trustees. And so that is a retitling process. And so a lot of what this first part of the settlement process is about is retitling the assets so that the successor trustees can get control of them. And also we're valuing the assets as of date of death because, of course, we're going to probably have to file an estate tax return, and that is the primary information that we need to know for the estate tax return. What was the value of the assets at the time of death? And that can take 6 to 9 weeks, or sometimes even longer, but it's a process. And so what happens is weekly or bi-weekly or monthly on a regular schedule, we have telephone conferences or even Zoom meetings to go over what's happened so far, what the tasks were, what's been accomplished, what needs to be accomplished, and then what's the next step. And we have regular meetings on a bi-weekly or monthly basis so that we can make sure everything moves along. And when all of that gets done, then we have another meeting. It's called the Transition Strategy Meeting. And the purpose of that meeting is to just make a bunch of decisions about what needs to be done for state purposes. For example, we're going to make decisions about how we're going to report certain assets on the estate tax return and what needs to be done. In many cases, we need to consider what are called disclaimers, which is a legal no thank you, which actually means that the person who would otherwise receive the property says no thank you, so it goes to the person who received the property if they died. But of course they didn't. And that's called a disclaimer. That has to be done within 9 months after the date of the death. And so it's really important for us to get the work done in the first 9 months so we know what we're doing. If there is a tax that has to be paid, that also has to be paid within 9 months after the date of death. Of course, in the COVID-19 situation, we have some extensions on that. But typically, the tax has to be paid even if the tax return isn't filed. And the tax return has to be filed within 18 months of the date of death. Because there's a 15 months. There's a 9 months and then another 6-month extension that you can have automatically. But you still have to pay the tax within 9 months. So there's a lot to be covered. We're going to make decisions about how distributions are going to be done, if there are trusts to be set up for beneficiaries, how those are going to be set up, and all those decisions get made. And then when we're filing an estate tax return, we go ahead and prepare the estate tax form and all of the appendixes and attachments and all of that, so that that can be filed with the Commonwealth of Massachusetts, and if there's a federal return with IRS. So all those decisions that we made in the transition strategy meeting and once we filed the estate tax return, we have to wait a little while for the Commonwealth or the federal government to say, okay, we accept the return, there's no further taxes due, we get a no tax letter, or they may say, we disagree with this or that, and we have to work that out. But when that's all done, it's time to fund the successor trust, which may be the family trust or the marital trust, or it may be trust for the beneficiaries. And so there's a process that we go through with that, with a telephone reporting system. And we have meetings with the people who are going to be the trustees of the long-term trust. And then after that, we have administrative support team meetings with those trustees if they want to have that support from us. So again, this is a quiz alert. These are the 4 things that occur at the settlement counseling session. If you're listening to this by recording, be sure to write these things down so that you know you're going to be asked which of the following is something that occurs at the counseling session, and 1 or 2 of them are not going to be things that occur at the settlement counseling session, so you'll need to be able to weed those out. It's a quiz alert. So again, we're talking about, as I said, we're talking about the cash flow analysis. We're verifying assets, getting title, getting signatures. That's, by the way, I didn't mention this before, but that's also where the service agreement is typically signed. And then we schedule our first evaluation and retitling telephone conference at that time. The transfer process navigator. So again, as I mentioned on the transition strategy meeting, we discussed the potential disclaimers, determine estate tax reporting strategies, and determine various different distribution, asset allocation options, and plans for the marital and family trusts or inherited trusts. So this is a diagram of really what happens. On the left-hand side of the screen here, and this is a married couple. We'll get to the single person in a second, but this is a married couple. When the first spouse dies, the surviving spouse still has a revocable living trust, and that still continues. The deceased spouse, however, their spouse becomes an administrative trust. That's right here. So all the assets that were in the deceased revocable living trust move into the administrative trust, and you can see that box is closed. What that means is that the trust is now irrevocable, and it's no longer revocable and amendable by anybody, because that's the only person who could do that was the trust maker, and they've deceased. So it's the administrative trust is now irrevocable, and now it's time for the successor trustees to follow the instructions that have been left by the deceased in the trust to go forward. Once we go through the settlement process, the administrative trust basically funds if it's a married couple, the family trust, and if it's a federal taxable estate, we'll also fund the marital trust. So you can see those are typically, for many clients, will only be funding the marital trust. There is a sub-trust of that is a marital deduction component of the family trust. But there's no need to get into that complex topic. But we will be funding for surviving spouses the family trust. So that's primarily what happens then. So, and then when the second spouse dies, here's what happens. We've got the family trust of the first spouse, and we've got the survivor's trust. They end up with an administrative trust again. So they go through the same administrative process for the assets that are in their trust. And typically what they do is they have separate trusts for their beneficiaries. So those trusts become irrevocable, and we establish those trusts. Now you'll notice that, for example, in this case, we have 3 children, but we end up with 6 trusts. What do? Well, the trusts are typically the same trustees, pretty much the same provisions, and so we can merge them. So we actually end up with just 3 trusts for the beneficiaries. For a single individual, again, we have the same rough pattern. We have the deceased revocable living trust, which, because the top is open, is revocable and amendable. Assets can go in and out. When the person dies, we have the administrative trust and their successor trustees take over, and their job is to control the assets that are in the deceased trustee's name. They control those assets, and then follow the instructions that are in the trust, and we end up with trust for the client's beneficiaries. Sometimes there's one beneficiary, sometimes there's more, but that's what happens. The property transfer and valuation process goes like this. There's at the first thing that happens is we ask for an estate inventory report. This is just to confirm all of the records that we have. Typically, that's not a very extensive project because we already know where everything is, because of course our clients have very faithfully and conscientiously filled out their annual asset review report. It's not a big job for us to get an inventory. Then of course we do the asset valuation. There are sometimes appraisals to be done. Sometimes we do get those appraisals. A lot of times we get those appraisals, for example, for real estate for the clients. And then there are transition talks and decisions. And we prepare for that. We support the clients in transferring and funding the trusts. And then of course, there's the asset review report, which we really need from everybody. And while you're alive, we need the asset review report. And for people who are doing their initial planning with us, we go through a red check review, make sure that we have their initial funding all set. There's a survivor support system. When the first spouse dies, for example, the survivor often needs a lot of support. There's tax return preparation and review. There are questions about the principal, access to the principal and what the priorities are. Sometimes the survivors need strategic financial planning and help with that. We'll work with financial advisors as well for that. And there's transfer and valuations for the beneficiaries inherited trust as well. So those are all things that occur while the settlement process is going on. So final thoughts and wrap up. Remember that there are counseling issues. There are always counseling issues that have to occur during estate settlement. The issues can come up and are often very complex. And so we like to review all of those. Those begin occurring in the first session for estate settlement. And there is something known as dangers opposite DOS, the DOS analysis for beneficiaries. This is actually on our website in the client resource page. It's called the DOS analysis. I would recommend that you download it. DOS stands for dangers, opportunities, and strengths. It's important to recognize the dangers that are extant with what's going on now. Sometimes we like to turn that around and look at them as opportunities, and we solve those dangers and opportunities with the strengths in the family, and that's the DOS analysis. So it's important for people to look at that and make sure they understand what they need to do, what the dangers, opportunities, and strengths are that they need to be prepared for. So next steps, review the website information. That's at hdlawgroup.com. The sign in is using the username step2 with a space between the step and the 2 and the capital S. Use the password member with a pre-cap M. There's a lot of resources there, and the recording that we do of this session is going to be uploaded to that. It's about halfway down the page, maybe a little bit more. There's a link to it. It ends up being linked to a YouTube that you can view online or you can download. So that's where all the resources are. So again, our 4 goals, we want to make sure you know the law firm name, what our contact information is. Remember there's a process, and the process produces the results, so please follow it. Give us an idea of the types of issues that you deal with, and the kinds of issues that you'd like us to deal with in terms of education, and we want to encourage your interest in planning and participation. Again, 911 info. When the emergency occurs, be sure to call the law firm. Locate the client's blue book. Locate the blue book is the manual that we've been talking about. We're going to have it in electronic form shortly. But clients still have their blue books, which has some important information in it. That's the operator's manual for the maintenance program. Locate the Lions Red Book. We've mentioned it before. And relax. Remember, there's a dependable process to follow. And again, this is a quiz alert, so make sure you understand what all of these things are, so that in the multiple choice that you're going to confront in the quiz will actually be easy for you. That's for people who are watching this recording. So, how do we get help from the whole family? There's a settlement fee incentive. If people have attended these sessions, and before somebody dies, then there is a reduced fee that we offer to our clients for state settlement. It's important to make sure that the disability and healthcare discussions occur between the clients and their family. And it's important for the family as beneficiaries to make sure they understand what we mean by wealth reception planning and watch session 4 of the Nuts and Bolts program. Our next session is the Nuts and Bolts program, which is on October 8th. That's for disability, what happens when somebody becomes disabled, and goes through the stages of that. And again, the session on maximizing your inheritance, that's Nuts and Bolts number 4, that's on October 29th of this year. So that is our session. Thank you all very much for attending, and I'm going to open this up for questions. Before I do that, I am going to stop the recording.